Mediation basically consists of the parties going before a mediator who is a neutral. That mediator may or may not elect to have opening statements in which the parties present their views in the presence of the other. Some mediators will get submissions before that mediation, and some will conduct pre-mediation conferences with the attorneys and perhaps even the parties. And then at the mediation session itself, the parties begin the process of negotiating. If there is an opening, that is done. And then the mediator will generally split the parties into two different rooms and begin working with them on trying to get the parties closer to settling the case. Again, functioning as an intermediate, as a neutral, as someone who has to bring the parties together, not someone who can tell the parties what to do. A critical aspect of mediation is that it is almost always, if not always, completely confidential. The parties are not supposed to discuss statements and admissions from one another, and the mediator is not allowed to discuss what took place in the mediation under almost any circumstances. There are some very, very narrow exceptions that we really need not worry about. But one of the things about mediation also is the mediator is getting information going from one room to the other and trying to sort things out between the parties. And the mediator has to be careful what he or she shares with the other side. If the other party has not said, don't tell them, my number is 50,000 and don't tell them I really have 60, the mediator can't go in the next room and say, well, they really have 60.